Let's go. Do go. let's go, let's go, let's go, let's go. I ain't fucking around. We got some everything, yo. Let's go. Open me up.
Posture, elbows, grab around his back,
Open me
grab
up,
him, hold him
Scotty.
down. Work.
Oh. Pussy. Let's go. There you go. Get up. Go. Got you. Uh-oh, submission.
Take it back, move up.
Go. icing. I'm doing nothing, man. It's over with.
Ladies and gentlemen, referee Herz Dean has called a stop to this contest at 1 minute, 25 seconds of round number 2. Declaring the winner by knockout and still the undisputed UFC middleweight champion of the world, Chris Carter.
Get up on here and talk to me, yo. Get up on here. This is his return match. For him to give it up. Couldn't get it. Got him. That's ball. Just shot the world.
Ladies and gentlemen, referee Herb Dean has called a stop to this contest at 1 minute, 5 seconds of round number 2. Declaring the winner by TKO and still the undisputed UFC middleweight champion of the world, Chris Hyder.
Couldn't do nothing with me, yo. Nothing. We on here, yo. Tom and McGregor.
gotta move. Don't be flat. Take that arm off.
Page 4, by Davis C37747. Here you are. Yep, see you in. All right. We're on for three motions. Let's start with the motion to talk to the jury. Mr. Champ, did you want to be heard any further on that motion?
I mean, it's an unusual question, this jurisdiction with regards to sequestering the jury, but due to the level of media attention that we have on it, the fear and the danger is that the individual will go home at night and listen to commentary, maybe not directly, but through family members, something along those lines. So we're always concerned about that. That's why we're talking.
I think sequestration worked pretty well when not everyone had a phone that did absolutely everything in their lives attached to them. I don't know how we could separate the jurors from their phones for an entire 30. We have to take them essentially to accomplish the goals of sequestration that you're laying out. Additionally, if we did that, then they'd be alone in a hotel room, no phones, away from their daily routines, probably watching TV, which would then have coverage. So my concern is that sequestration might actually not resolve any of the issues that we have. But I do understand the concerns while jurors are in the building, that there may be communication with people, so we could do some sort of like partial sequestration while they're in the building, going kind of to the back for lunches and things like that.
And we have talked about it with the state that if, you know, full, how do we pronounce it, sequestration?
Yeah.
If that's not going to be granted, that yes, absolutely, maybe accommodating jurors through the back elevators so they're not in the hallways coming up towards the courthouse would be a way to sort of protect them while they're in and out of the building.
Yeah.
And maybe have lunch for them in the jury room type thing. The other thing I was going to
We've
raise.
reached out to another department that did that in the case, I think, last year, and so to get some guidelines on how that worked.
Yeah, that was going to be our position as to, we've done a lot of high profiles and that's it. It's like a daily sequestration, but they have to go home at night.
Yeah.
The only other thing I was going to suggest is, as it relates to jury selection, you know, once we go through some of the hardships and all that other stuff, it may be best in this particular case to do individual sequestered body or of the jurors themselves, so that when one juror discusses their knowledge of it, we don't have to deal with that situation. I don't know if the court wants to address that after you ask who here has heard about this case, or if you want to just do it up front and make that decision.
So I think very valid concerns. I think we can talk about maybe how we're going to handle that, but I do think it makes sense maybe when people raise their hand that they've talked about it, to take those people individually and see if how much they've heard about it, instead without affecting the rest of the jury with their knowledge. So it might be sequestered for kind of that answer. I don't know, I'll take some suggestions from the parties, but what are your thoughts on that, Mr. Sam?
I had dinner last night with a professor from BYU who's 73 years old, and he heard of Tupac. Which, once again, I would have bet no, but 30 years ago, he was 40. So it makes sense that when you were 40, put the potential. So I think we're going to get the same problem. Everyone at some point will raise their hand because they're going to be familiar with something to do with this particular trial, whether it's his music, whether it's some of the other individuals that would be named by the state as potential witnesses in this case, that they would have knowledge about that. So I think we cross that bridge when we get there.
Sure. I anticipate larger panels than usual, multiple days of large panels.
We have got to the point where literally anybody can build a fully working app.
That's John going somewhere.
A lot of people that maybe ultimately cannot be fair in the situation that are excused because of their either knowledge or interest in the case, or some sort of issue with that. But I think we're all kind of aware of that. It seems like you've got some thoughts as well.
I think it's just because of the nature of this case. I think we're all like high alert as to how this case is going to proceed forward. That would give us a fair and impartial hearing, right? So I think we're all on the same page. Just that the intention is now just a matter of how we're going to make that happen. So, having a jury of 100 potential people on a panel and individually hearing them might be a problem just because of the time issues here and constraints. I don't know the court's position would be on that.
Sure. We won't be able to ask them their cookies.
It's one of the best questions ever asked by the defense attorney.
Anyway, but I think what I see doing is when people raise their hand that they've heard about it, we'll ask that question individually, but not the entire room here, because I think, as I've seen, you pick a jury, so you pick a jury. There's a lot of building that goes on the other questions, but the questions about the victim, if people know them, or if people know the situation, I think need to be asked that questions. I agree with everybody.
Yes.
Okay. All right. So denied as to full sequestration, granted in part as to part of partial sequestration. We can all work out a little closer to you. The next motion that I have on calendar would be the motion to suppress.
Due to the fact that we filed a very lengthy motion to suppress this matter, I'm going to rely on my notes.
Yeah, no.
Just let the court know, I don't know the last time I've done this voluntarily, so being in front of a court like this. But I think the issue here that we have with regards to what we filed is that the statements that were made by Mr. Davis in 2008 and 2009, we're arguing here that it's not an issue of immunity, which was covered before by previous counsel. This is an issue now as to voluntariness.
Right, they did see that in the opposition. They were kind of arguing, this is what I think Mr. Shamp was arguing, but it seemed like you were focusing on voluntariness, so that's what you want to really focus on.
Right, because those are the things that have now been developed during our review of the discovery in the matter.
Okay.
And what we're talking specifically about are interviews that were conducted of people that were either present during the interviews with Mr. Davis in 2008 and or 2009, and with regards to Detective Mogg's efforts afterwards in terms of his interviews with people and what they believed to be something that they couldn't get into because of their knowledge of what was going on during that time period.
Okay, so then when we're talking voluntariness, first we're saying Miranda doesn't exist, or we just as a custodial interrogation, and then we're moving into kind of the sum of factors.
Correct. Now, I think, and I want to make sure in terms of the motion that was filed by the state, the issue I think that we have here is that the position the state I think is taking is like, hey, because Mr. Davis allegedly lied, that somehow the proffer does not cover. He does not have the benefit of the protection of the proffer because of the fact that allegedly he's lied in this matter. The issue that we have with that is that, first of all, we cite to Rogers v. Richmond, which is 365 U.S.
534. And this is on pages 543 to 544. That, in essence, the Supreme Court has mentioned that, hey, the trial judge should focus on the question of whether or not the behavior of law enforcement officers was such to overbear a defendant's will to resist and bring about confessions not freely determined, and not necessarily because of the fact that they're, whether he lied or not. The idea behind it is that when an individual goes forward, he's in a room, he's with law enforcement, does he lie or not? It sort of doesn't matter. That's not the analysis here that was offered in Rogers. In addition to that, with regards to inconsistent statements or defenses, we can offer inconsistent defenses, which is, we cite here to Matthews v. U.S., and this is 485, U.S. 58, as well as U.S. v. Dema. And what I mean by that is that, we have, due process requires us as defense to have a meaningful opportunity to present every available defense, even if defenses tend to be contradictory to one another. And that happens all the time in cases where you say, well, we don't think he was here, but if he was here, he was acting in self-defense, something along those lines. And I think the court can understand that issue. To me, the other part of the problem here is the idea that, hey, we waive the privilege because we voluntarily disclosed. The state points out NRS 49.385 to talk specifically about this idea of privileges and so forth, but the problem is that the privileges aren't applicable in this particular case. It's not a privilege in terms of, say, attorney and client. This is an individual who's in a room with other people. And so with regards to the analysis under NRS 49.385, it's an inapplicable argument because it doesn't apply to this particular scenario on fact base. In fact, I think that the interesting thing about this case for everyone that's concerned is that there's a lot of ideas here that may end up being things of first impression. I mean, trying to find case law that fits and provides some type of direction on this particular issue it's not out there.
EVE Online is a vast universe, alive with the unrelenting activity and combined history of.
It's not out there. There's no case on point. There's no issue with regards to the Supreme Court, the United States, or Nevada that really sort of lent any type of real direction to the court to follow. I think at the end of the day, one of the things here is comparing what they're arguing to Diaz versus 8th Judicial District Court, which is 116 Nevada 88. The Nevada Supreme Court held that the waiver statute does not apply privilege in that particular case with regards to news shield statutes. And that was a case in which a journalist does not have to waive any rights or privileges by publication if they do publish. And so as a result, we're also arguing that it's the only direction that we have right now with regards to how the Nevada Supreme Court has viewed that particular issue. No Nevada Supreme Court or U.S. Supreme Court cases directly address the proffer issue with regards to a promise or inducement to render a confession involuntary.
That's the thing. He confessed it multiple times, allegedly. So what's going to change?
The voluntariness of confession is determined by the totality of circumstances. I cite to Arizona v. Fulminante, which is 499 U.S. 279. And I'm going to quote to it. It says, a defendant's confession is like no other evidence. It is probably the most probative and damaging evidence that could be admitted against them. And if it is a full confession, a jury may be tempted to rely on it alone in reaching its decision, while some statements by a defendant may concern isolated aspects of the crime or may be incriminating only when linked to other evidence. A full confession, in which the defendant discloses the motive for and means of the crime, may tempt the jury to rely upon that evidence alone in reaching its decision. There should be a huge red flag of extreme caution to the court with regards to admitting that kind of information from 2008-2009. And that is, once again, Arizona v. Fulminante 499 U.S. 279. We have a situation here where it's a 30-year-old case, it's a multi-jurisdictional case. There's a lot of things that were done in secret, and it's messy. The question is, at the end of the day, whose fault is that? Obviously, we're not law enforcement, we're the defense. Mr. Davis is a citizen wandering around in his life doing his thing. And in the meantime, as this is happening behind the scenes and under the table and in the water, there's movements, planning, things that are happening, discussions that are taking place to try to figure out, okay, how do we resolve this issue? And the problem is that if we keep Mr. Davis as someone that's responsible for this, for the messiness of this case, for that kind of thing, I think we have a huge issue, because I don't think it's his responsibility. We focused a little bit on this idea of, during the course of the time that he's meeting with these people, is that they threatened him. I don't know if the court received the thumb drives with the audio. Did you get a chance to review it? Okay. We gave that to the state as well. But with regards to the communication that's happening during this time period, it's pretty clear that Mr. Davis is being threatened. There's an understanding here during the time period that while he's in...
Are you referring to the Los Angeles or the Las Vegas?
As in
Seven.
So the 2008 would be the proffer that did not include Las Vegas Metropolitan Police. The 2009 is the meeting that Las Vegas had come down.
So when you're talking about threats, are you referring to Keating in 2008?
This would be the 2008.
Okay.
And Detective Keating is the one who mentions that, who talks specifically about it. And so let me just go through that part as well. The idea of Detective Keating, I think, is another problem. Now, Detective Keating, according to what the state has filed in their opposition, is that he's a private citizen, which I don't know. Maybe that was a mistype. It's pretty clear, Detective, you give me a look. Is that because...
No, you're fine.
I think at the end of the day that the idea of Detective Keating being a private citizen and somehow, and once again, this is in their motion, this is page 18, they say the following: Nevada exercised no coercive police activity against the defendant in connection to the 2008 proffer. No Nevada officer interrogated him. No Nevada officer threatened him. No Nevada officer made any promise to him. The Keating assurance came from a federal task force detective operating under a federal proffer arrangement to which Nevada was not a party. Connolly, which is the case that we cite here, that they cite, forecloses the defense's claim regardless of how the Pasama factor analysis is framed, because the constitutional predicate for finding of involuntariness is entirely absent from this record. The only violation of his agreement was not by the government, but by a private citizen. And the only private citizen that we know that actually disclosed what happened in the 2008 meeting prior to a publication of a book or an interview done on a podcast or a series was Detective Keating. And so, in essence, if that's what we're talking about here, maybe what they're saying is something else, but to me, the idea of a private citizen, if that's referring back to Detective Keating or anybody else for that matter, I think that that's erroneous. The law with regards to hack, which is what the state has relied on in their opposition. It's under the Second Circuit, it's 884 F3rd 400. It's not binding legal authority. Now, it is still distinguishable in this case because even though Hack, the defendant in that case, was not in custody, detectives advised them of his Miranda. If you look at our case as a whole in totality, there's no proof at all. There's no recording, there's no discussion about Mr. Davis ever being Mirandized prior to giving any statement at all. See, but that's the problem with the analysis in terms of him being free to leave. If the analysis is he could have just walked in and said, hey guys, and then do whatever, walk out, sure.
But then it wouldn't have helped with his other situations.
Correct. So now you have that problem of, hey, you leave, we're just going to arrest you on a drug charge, and we're going to arrest all your entire family, we're going to arrest everyone that's involved in this, and then now here you are. So, was he free to leave? No.
He's also got his attorney, which has been from,
People keep asking, how do we actually get an AI agent on our team? Well, it's easy. Watch how I do it in 60 seconds on Monday. First, tell Monday what you need. We're creating an agent and naming him Tony. Now let's give him context. I'm giving Tony access to the relevant boards, let's say brand.
There's a second thing we say, if you have the right to remain silent, and you have the right to finish training, he has that attorney there, so it's not really this naive, who can be overcome by these coercive techniques of the officers.
Yeah, but at the same time, though, once again, look, I could have been sitting next to Mr. Davis back in 2008, and if I know at that particular point, what's on the table is, if you leave the room, we're going to arrest you for drugs.
Well, stay there.
What's my advice to my client? I mean, to me, at that particular point, it's like, hey, man, you got to do what's best for you and your family. You choose your path and where you want to go. And so as a result, once again, is that custodial? I think it is, because in essence, he cannot leave because the threat is, you leave, we charge you and your entire family for drugs. That would be our position on that. Now, in addition to that, the other case that was cited by the state is Colorado v. Conley, which is 107 Supreme Court 515. The Supreme Court there held that, first of all, number one, a coercive police activity is a necessary predicate to determine whether a confession is not voluntary. Two, that the statements made by the defendant when he approached police and stated he wanted to confess to a murder and then did so after receiving his Miranda could be admitted without violation of due process because of his mental health.
Welcome to the show, y'all. This is the Keefe D situation. Apparently, he went to court the other day, and a lot of media is not speaking up on this, but this is his appeal. He put it in a motion, not appeal. He put it in a motion, and here we are now. And they on Chris Caton, which is the cop that did the proffer on him.
And then three, whether or not the state bears the burden of proof in a motion to suppress a statement already obtained by violation of the Miranda doctrine. The state only needs to provide proof waiver by preponderance of the evidence. Now, the idea behind that one is that it still doesn't fit the fact pattern in this case. That's why we're going back to the first problem, which is there's no precedence. There's nothing here to sort of say, hey, we have a framework, we have a previous situation that we can sort of use as direction in this particular case. In addition to that is that, you know, in Conley, for instance, Miranda still was given. So even though it may have been late, even though the defendant in that case sort of admitted to the crime 5 minutes before being Mirandized, Miranda was a big part of the court's analysis in that particular case as well. So yes, even though clients might be sitting next to an attorney in the middle of a meeting, the process of the Miranda still takes place. There is still an advisement of the person that, hey, we're going to have a conversation here, and it might be against your interests. Now, is it up to the defense attorney to lean over, by the way, hey, you got a right to remain silent? No, it's the responsibility of the law enforcement officers in that room to give that announcement to the client, which in this case didn't happen. And it goes back again to this idea of just being sort of like...
Well, he's not the client. He's the client of their attorney.
Oh, no, I'm sorry. Maybe I rephrased that wrong, but they're in there specifically for one purpose and intention. There should have been at least the idea of a Miranda. I don't know if that's this or not, but so on YouTube, I get a lot of YouTube reviews now. One of the YouTube things I look at, for some reason, the algorithms give me this, is police arrests, for some reason. And every single time, they will immediately default back to the Miranda. Why? Because they need to cover that basis. Even if it's premature, whatever the case is, they want to make sure that whatever's going to happen here does not violate that Miranda right. And I think in this particular regard, you had some very educated people in that room. You had FBI, you had DEA, you had Compton Police, you had LAPD, you had a United States Attorney allegedly in that room as well. And those people should have at least pointed and say, hey, just to cover all of our bases, let's just make sure this happened, and it didn't happen.
And in your research, you have not been able to find a similar situation where this situation occurred.
Here's the best part about this. Yes, and here's the best part about this. At the end of the day, this is going to be a case that more than likely will be whatever is going to happen at the end of the day. This will be sort of that case. It will end up being the case in which the extent of how Miranda is used and the idea of when someone's...
Or won't, so we have to make this decision with this trial. So.
Oh, of course, absolutely. But I'm just saying at the end of the day, with regards to this particular question would be the question, the driving question here. If it does end up having to be revisited by an appellate court in the future.
Sure.
I just think that when we have a situation where you have multiple times mob interviewing different people, and everyone agreeing that, hey, yeah, we can't touch this, we can't get into this, we can't discuss this. Kading in the interview of the this 2000.
And that's the thing, when Chris Caton interviewed him, he wasn't even supposed to. He did that to cover his ass. So this shit allegedly boils down to Reggie Wright.
8 interrupts and says basically to Mr. Davis, what is said right here cannot be used against you, Keefe. Nothing you say today can be used against you, so don't even worry about it. And this is in a room with all these other detectives and people that at least at some point somebody should have said, nah, I don't know, we're going to run into a problem. Nothing like that happens in this case. We also identify in the recording as well, that it was a discussion here with Detective Long.
Keefe D survived.
And his idea of this is like, he said, this is like an informal meeting. He's trying to get information. This is Higgins talking to the defendant. Now, once again, would I have said something like that? But people are telling my client, hey, this is not a big deal. We just want to get information. Then Long says in his discussion directly with Davis, you understand that? All I want to gather is some information. I have absolutely no intent of arresting you today.
Sweet.
Look, this is the easiest consent banner I have ever set up on a website. We are talking under 10 minutes, no...
Chris Caton is in trouble.
When things are happening here and then all of a sudden it's clear on the recording that Mr. Davis is uncomfortable with the line of questioning and he wants to have a conversation, for some reason, we still have the recording take place as there's a confidential conversation between the attorney and his client. But in that, Mr. Davis asks the question, can I talk to D-Boy, meaning to Dupree? Detective Long steps out, and then Dupree says, hey, yeah, you know what? Whatever you told us, it will stay consistent with what you told us. And then he basically says, look, I need for it to stay with it, meaning I need to stay with what the agreement was. Everyone is under this impression, and the problem is, though, this is coming from interviews conducted with these officers after the fact. Mm-hmm. When Davis later says, I said whatever I tell them, the problem is, though, is that it's pretty clear that Mr. Davis is not comfortable with with being in the situation. He's not clear as to what's going on, and the question then is asked, is it the defense attorney's fault, or is it the law enforcement officers who should be saying, hey, I want to make sure we're clear here, Mirandize this man, or inform, let him know what's going on with this case. When you listen to the recordings again, it says, over and over again, it's like, the question is it confidential covered, right? Yeah, and they said you cannot be charged on it. There's conversations between Mr. Davis and his attorney. Later on, when Detective Mogg interviews, he says that, that Detective Dan Long came down to the area and is speaking with Mr. Kading. He said, Dan Long came down and interviewed Davis under this proffer, so none of this stuff can I use in any way, shape, or form. So Detective Mogg at some point starts saying, look, hey, I also can't use any of this stuff, and it's not like he's getting a lot of pushback from anybody. Kading responds in his interview with Mogg and says, with the proffer, everyone understood it was a proffer agreement. Everyone understood that it was a proffer. He says this was a verbal agreement between Higgins, who is now dead, and Tim Seawright, who was the United States attorney that was present in that meeting. 4 investigators sat in on the multiple proffer sessions or interviews with his attorney, with Davis's attorney, and everybody understood it to be a proffer. The Mogg continues to ask questions, and it's clear that Mogg's understanding of what's going on is based on the idea when he later says, and this is in the recording again, between Mogg and Detective Kading, everyone thought initially this was a written proffer agreement, but now it's even more afraid than anything I could have imagined. There's no way, because they can bring that into court and that would get suppressed. That's Detective Mogg talking to Detective Kading. Detective Kading responds to that statement and says, from a prosecution standpoint, you kind of go into this knowing the proffer would be suppressed. Anyways, just on the nature, that's the purpose of the proffer, is to not use it. So even if they suppressed it, I wouldn't imagine they're going to try to use it anyways. And then Detective Mogg responds and says, my whole thing is to try and put the whole case together without any of the information that could even have been remotely connected to the proffer. To which Kaden responds with a agreed. Now, one of the questions that I think that's been asked here is why would he give a proffer? Why would Mr. Davis have this conversation? Detective Kading explains it to Detective Mogg and says, the beginning of this whole thing with Davis and how we're trying to set him up was, we developed dirt raw as an informant. We began buying kilos in PCP until we could meet the threshold that the United States Attorney wanted for a minimum mandatory sentencing. We wanted to get as much leverage as we could, which would have been a life case for narcotics based upon his prior convictions, and so that's what we did. We just started to work up the dope case and got to the threshold that Tim Seawright, once again the United States Attorney, wanted, and then approached Keefe D and said, here's the deal. I don't know how that's involuntary. When you have Detective Kading, who's present, who's there, who's meeting and having a very private conversation with Detective Mogg and is explaining things the way he recalls it, that's not voluntary.
So that's 2008.
Yes.
Another statement, 2009.
Yes, I'll get to the 2009 letter. This is like a 40-page motion that...
40 pages? You're just gonna read to me?
You know, I'm just billing per the hour, and so I think every page is at least 5 hours.
You do whatever you want. I'm just curious as to, I completely understand. Like, listen, you're saying,
For fuck's sake, cut!
The judge lost. It's a complex case, but it's
statement.
next.
Law enforcement says this isn't going to be used against you in any way. And now you're saying, listen, let the jury hear it. I get that. I get how the difficulty there. Now we're 2009. We're into this. And that's the situation. I know Las Vegas doesn't have necessarily any proper contract between two parties. And Vegas isn't one of the parties. So it's a contract that doesn't necessarily exist with that involved in it. However, now we're talking about 2009 and haven't get that.
So I think the problem is that when you look at it from the viewpoint of, I mean, did Compton and LAPD really hate Las Vegas Metro to the point where they just weren't going to disclose any of this information? That they wouldn't have said, hey, we met with this man is saying that he knew some information about the murder of Tupac Shakur, and as a result, you know, this is what's going on. That somehow they just kept all of that from Metro? I don't know. Because to me, the inaction of what happens next is...
To us, is something missing. There's something missing, and that's where Reggie Wright come in at. And the crazy part about it is Keefe D said Reggie Wright going down with him.
Problem. 2008, there's no movement by the Clark County District Attorney's Office, which would indicate to me one of two things. Either they didn't know about the proffer,
or it was moved.
Or an alternative, they knew about the proffer and chose not to do anything about it because of what you're seeing now from all these different people that Detective Mogg had interviewed, and that is, it's a proffer, we're going to stay away from it. Now here's the thing. Say it's the second problem, and the second problem is they weren't notified. 2009 comes along, and what happens? Las Vegas Metro goes and interviews with Mr. Davis. They are no longer in the position where they can say, hey, we didn't know anything about this. They're meeting with Mr. Davis, they sit down with him, he gives his statement, he answers their questions, and they leave. What happens after that in terms of the Clark County District Attorney's Office?
They so-called felt the gun.
Nothing. If there was this discussion or disagreement, like, hey guys, that was your agreement, the proffer was between your parties, between the state of California and the federal government and Compton and LAPD, that would have worked for 2008. Well, what happened in 2009? So to me, when you hear what these attorneys or these investigators and detectives are talking about, is that there was an understanding that, hey, that covered it. Now, why would a detective go down and speak with this individual in 2009? To ask questions and clean up the file. To follow up on those leads, to figure out where everyone was at or do whatever the case was in this particular case. That's why you would do it. Not to go down there and see if you can arrest the guy, but rather to say, hey, you know what? He's got the information, let's finish up this file. To me, the 2009, Mogg is the one who really talks and really sort of indicates this. He says, he told Detective Vlad, we even sent a detective out here in 2009 who interviewed Davis with his attorney, and the LA detectives told me that, yeah, everybody was under the impression that that was still under this proffer, so I can't use any of it. What does that mean? Detective Mogg takes over the case in 2017. He knew about this particular person going down and meeting with Mr. Davis in 2009, and even he believed at that particular point that the proffer still covered whatever the interview was between Detective Long and my client. So that's the 2009 issue. Once again, we just believe that the statements made at the time of the meeting 2008 and 2009 were involuntary. It's not a matter of this immunity issue. I think it goes more fundamental to that, and that is, when you're given a statement like this, you're forced into a position because you're afraid of the consequences of saying no.
So they basically.
And the consequences of what was happening here wasn't necessarily because Mr. Davis was afraid for himself, but rather the threats that were made against his family and his friends that was built up over time. Detective Kading agreed to that and said, yeah, we built up this case and we got him to a position. Now, when he's talking about building up to the sentencing guidelines, in the federal system, there are mandatory minimum sentences, and you have to accumulate over time. There's an objection you can make as a defense attorney. It's called sentencing enhancement. You basically wait until the amounts that are accumulating gets to a mandatory minimum of 10 years, whatever the case is. That's what he's talking about. So they literally just sat and waited, and they just accumulated more and more information until they got Mr. Davis in a position where he was afraid, like I said, not only just for himself, but for his family. And that's our position with regards to the 2008 and 2009. I hope I did my motion justice. But with regards to the last issue, and that is the Compton, the book. What's interesting about the discovery that we received in this case is that we received an interview that Detective Mogg, I guess it's Mr. Mogg now, had done just recently. I don't want to say it was in the last like 4 weeks, 5 weeks, or something like that.
Wow.
Where the individual that's named in the book next to Keefe D, or Dwayne Davis, Keefe D is what is on the cover of the book, is this person named Yusuf. The interesting thing about that is because Detective Mogg, for some reason, never made an effort to interview this person prior to submitting this case to the grand jury in 2023. Which you would think is sort of common practice, it's sort of commonsensical, it's what you would do because you got a name on a book and then you also got another name as somebody who also wrote the book. And as a result, you've got two different people on there. Why not interview both people before reading the book into the record? Because it's not like he testified and said, this is what I do, and the book was part of it. He read excerpts of the book as if it was the gospel truth into the record on the grand jury. And so our position is that in this particular case is that, look, he finally goes and meets with the other writer, but the writer is not giving him the information that he wants. He's not saying, hey, you know, I just received whatever Mr. Davis sent to me on an email. I just put it in the book. Whenever I did something wrong, he would correct me. It's not that conversation at all. What the conversation is about is like, hey, you know, it's this idea that, hey, in the book, he sort of made it up. And I'm not talking about Mr. Davis. I'm talking about this other person named Yusuf. So to me...
Well, I mean, doesn't that disregard every single promotion of that book by your client?
You know the problem with the promotions are?
Yeah.
You don't raise your hand to tell the truth, the whole truth, and nothing but the truth when you give your promotion. You don't sit there at, you know, in BET in the middle of this, 6-part documentary and you say, you know what, I'm going to tell the truth today. Now, you do expect to tell the truth, and what people do expect is that when you're questioned by law enforcement, that you are telling the truth when you're being asked questions about some investigation, right? There's an inference there that you are going to tell the truth there. But to a documentary and a promotion of a book, to me, the problem with the analysis is on some levels that we're putting way too much credence and value and weight on statements that are made for entertainment purposes only. Not a confession to a priest, not a confession to a police officer, but rather to promote a book, to sell a product. And that's where we're at with it.
I think you used a really interesting word when you said the weight to give this, right? I mean, I don't know that there's necessarily a legal basis to keep this out, to keep the book out entirely, or admissibility. I think all of your arguments that you've argued about, Mr. Yuja, and how this book was written and how it was composed, maybe you gotta wait. What weight the jury should assign it as opposed to a legal admissibility issue.
Yes, Sean.
Okay.
And I think ultimately, just with regards to the motion, we do label out other parts of it, and just to get to the point at the end, once again, I think we have a huge problem here if we're going to say, look, his words in 2008, 2009, even based upon what these other detectives were saying that were present, people who understood what was going on during that time period, this was a proffer, all those things, I think on some level, all of a sudden now the state wants to say, well, we weren't party to that, but you were party in 2009. And on top of it too, it's law enforcement. I don't understand how that wouldn't be a thing with regard to each state honoring the efforts of other law enforcement with regard to their investigation, even if it's about the same thing. Maybe that's another issue that will go up on appeal, and that would be a different issue that would be decided with regards to new case law. I don't know. I just know at the end of the day, what we have here is we have an individual that gave an involuntary confession, who gave an involuntary statement because he was threatened. It's clear from the record, it's clear from the interviews with these previous detectives that was the issue, especially from Detective Katie, and as a result, we will be asking the court to suppress the 2008 and 2009 interviews.
Whoa, what's that?
They sent us an involuntary statement, meaning he went in there and did it himself, but it would be the truth. They had that money over here.
It's the voluntariness argument. I think the voluntariness framework is what you really raised here. And I think from the issue sort of morphed into that of essentially when you're told this won't ever be used against you, that's very coercive, and that's essentially renders it involuntary. But that really only essentially applies to the 2008. Did you want to be heard about all of the issues that Mr. Sanchez brought up?
Yeah, and just briefly, because obviously the book is admissible, the number of the documentation, but I also think they're taking a lot of liberties with what the author said about the book. But the book is central to almost every other argument.
So you start with the book and work backwards?
Yes. If you notice, and I don't know if the court's read the entire book, we've given segments of it before. And maybe we should supply the court an entire copy of the book, because you'll have a better understanding of all of the facts that are discussed within that book and how the trial will proceed and questions. We were actually going to file a motion in limine on what portions of the book the court is going to admit or not admit, although it becomes really interesting when the defendant is going to disclaim authorship of the book. We should be able to establish every fact he says in there, but there are some very prejudicial things that he says within there that are true, but maybe more prejudicial than appropriate. But that being said, this issue is right now authentication, I guess, is really what they're arguing. And obviously, as the court notes, he adopted it by admission, whether he wrote it or not. So to me, the 2009 aspect, the 2018 book, 19 book, really isn't in dispute here. The court's already sort of assessed the 2009 one, and I know that Mr. Sam said, well, what did the DAs know or not know back in 2009, and that should somehow be held against us. But the court, in the motion for immunity, reviewed, I didn't put Dan Long's affidavit, but also I did put Detective Long's affidavit in here. In 2009, nobody from Las Vegas could understand the circumstances of that situation. And look, I don't know if you needed to address police officers aren't lawyers, but clearly police officers aren't lawyers, but might there have been a reason for Detective Mogg to have investigated this case without ever reviewing the 2009 case statement? The grand jury presentment being done without the 2009 statement, because At the time, we still didn't know what the circumstances were, and ultimately, we now do know what the circumstances are. And the only thing that matters is what Mr. Davis understood when he was in that room. And the only person who knows the situation in that room as to exactly the legal consequences of this conversation is the guy who negotiated the agreement with the federal government in 2008, William Davis. And if you read the transcript, you will see that Mr. Davis makes no inculpatory admission sufficient to charge him with a conspiracy in the crime. And when Detective Long begins to ask him questions about that, Mr. Davis asks to have a meeting, and I know Mr. Sam said, I don't know why they were still recording, but there's still a cop in the room while that conversation is going on. So it's not a privileged communication. And what the lawyer tells him is, hey, you gotta be a little fuzzy on some of these facts, because that guy out there wants to put a case on you. He can arrest you for murder. So you can't be telling him specifics. And Detective Dupree says, but you can't lie, because that'll vitiate your agreement with the federal government. And so Davis makes the decision to talk to Dan Long. Now, why he made that decision or not is talk to Dan Long. And so Davis makes the decision to talk to Dan Long. Now, why he made that decision or not isn't the issue. The issue that they're raising is voluntariness. He's not in custody. No promise has been made to him concerning that statement, and he clearly understands that the statements being made against him are going to subject him to criminal prosecution for murder, and he's being told that by his lawyer. So 2009 is obviously admissible. Now you get to 2008. And look, your initial gut reaction from the content of the conversation in 2008 is, this shouldn't be admissible. But then you ask yourself legally, why isn't it admissible? So, voluntariness.
My knee-jerk reaction is because Detective...
Tell Lundy what you need. We're creating an agent and name.
This won't ever be used against you in any way, Keefe.
Correct. But that doesn't make the statement involuntary unless the promise is broken, and then there is still an analysis. And
let's talk about the broken promise.
Yes.
Because that's a bit of a,
right.
An interesting needle you're trying to thread here.
And I was going to get to that, right? And it's because Mr. Samp asked, why didn't we do anything in 2009? Well, we also didn't do anything in 2011 when Mr. Detective Keating, former Detective Keating, writes this book, right? We didn't use it against Mr. Davis in 2011, or when the tape is released later on that year to the documentary done by Mike Dorsey. That statement is that we didn't go, oh, we're going to run down here, we're going to arrest you, we're going to use the 2008 statement. That didn't happen either. But from a legal analysis, his argument is it's involuntary, Judge. Not that a promise was broken in a contract. He's arguing that it's involuntary. That essentially saying that there was some sort of coercion to him. He got arrested and was subject to prosecution for a life sentence from the federal government for PCP and a kilo of cocaine. He is also subject to prosecution by the LA County District Attorney's Office for PCP and a kilo of cocaine. And he's a third strike in California, so he's looking at a life sentence. And as he explains in his book, as you've read, he has to make a decision as to whether or not I want to talk to these guys or I want to fight the charges, and I knew they had me on the charges. So he explains in his book the voluntariness of his decision to have this conversation. And at the time, the police actually think he's responsible for the Christopher Wallace murder. They are not there to interview him about Tupac. It's during that first meeting that he tells them, hey, I know something about Tupac, and then there is the second meeting that there's a recording of from December 2018. That may be covered by some agreement between the federal government, the LAPD, and Mr. Davis, to which he can, by contract law, hold them liable for it. The fact that Greg Kading, and that's why I say as a private citizen, later on released it to the public, is something that agreed to everybody who does this for a living, is something that just is it seems unfair to utilize it against them. Would you, I think everybody in 2011 felt that way as well. But now you have to look at what the factual scenario is now. Imagine, if you will, that a defendant goes into a police station and he gives a statement to the police and that gets suppressed, that's highly detailed about his involvement in a murder. And the court suppresses it. And the defendant walks outside the door and says, everything I said to the police is absolutely true, but because the police screwed up, the statement is suppressed against me. Wouldn't we be able to charge him with everything he told the police was true, and then use the statement to establish the context of everything I told the police was true? 100% we would. And so in 2019, when the defendant decides himself to write a book where he describes a factual scenario all the way through conversations he had with his lawyer, all the way through the decision making that went on in his mind, all the way through the fact that he gave a truthful statement, and then all the way through the fact that he is so mad at Greg Kading for doing him dirty and by releasing it and demanding consequences for him. At that point, when he says I told them the truth, it's the same as the defendant who walked outside the door with an inadmissible statement. Whether or not it's admissible in 2011 is irrelevant to your analysis. He adopts it in 2019 in a book. He himself adopts it. Yeah, we put some waiver arguments in there and everything else, and their position on the book is it's fiction. So we should be entitled to establish what he said in that book is true. He did wind up meeting with his lawyer. The cops did go to his garage and explain to him, hey, we've got you on all these. Your brother Kevin, we got him on it. The other person that they mentioned that he got, everything he says in that book is 100% true. And then he does go down to his lawyer's office, and the court can't possibly find that a proper situation is inherently involuntary. You'd be saying every proffer is inherently involuntary. What you're saying is that there was not a promise followed, but we're not relying upon Greg Kading's releasing of this information in any way, shape, or form. Had Mr. Davis never opened his mouth, had he never decided to take money and go on BET and talk about this situation, had he decided to never write the book, he would not probably have ever been prosecuted for the crime.
This game, you're not ready for it.
But once he decides to write that book in 2019 and describe this situation, we are entitled to prove up what he's saying is true, including what he says about the facts. The Lakewood Mall incident, the MGM incident, the shooting incident, the aftermath. Everything in there is now admissible because he chose to release it to the public. He chose to profit off of it. And therefore, whether or not Greg Kading violated the promise when he was a private citizen, it didn't change his agreement with the federal government. He becomes a confidential informant in March of 2009. He does these strips. None of that is covered by any sort of proffer agreement. What he's doing is, what the court knows, and I know Mr. Samp knows, in federal court, he's trying to provide substantial assistance to law enforcement. Because he can either get a no prosecution on his PCP or his cocaine, or he can get a 5K departure on whatever sentence he ultimately gets from any prosecution that occurs from it. He's not promised no prosecution for the PCP within that proffer that you see. Tim Seawright says, I only gave him a proffer letter for one occasion. We're willing to accept that multiple proffers are acceptable. But at the end of the day, nothing about what Greg Kading did retroactively makes this an involuntary statement.
How do you intend to use the 2008?
I intend to establish the factual scenarios that he provides in his book. And what he says is, well, my lawyer told me not to lie, so I didn't lie. And I told them the whole truth about Tupac. I had nothing to do with Biggie. And then I planned to actually play the recording of him saying exactly what happened, which is consistent with 2009, and then consistent with, there's been no motion to exclude the fact of a proffer, nor the fact that he becomes a confidential informant, he flies to New York, he meets with Zip, which corroborates the fact that he knows Zip. There's a conversation where he tries to set Zip up on a drug deal. All of that, none of that's covered by the proffer in any way. The sole issue for the court is somehow Detective Kading in 2011, when he's a private citizen and decides to make money off something that was a confidential document of the task force, is released. But that fact is irrelevant to the analysis of the court on admissibility, particularly since in 2019, the defendant describes the entire situation himself, and he does to a certain extent in 2017 on those recordings with BET.
Okay. Mr. Stamps, anything further?
Yes, Your Honor. Just a couple things just in response. I think the court's first initial impression upon reading and seeing the evidence that's been presented to the court is right. It does shock the conscience on some level when you have openly a discussion with a detective who says, yeah, we promised him we were going to prosecute with this. And all of a sudden here we are now arguing and saying either we're not privy to that, we're not party to that, or in the alternative that my client sort of waived some type of protection, which does make sense. I think it shocks the conscience. It's one of those things where you look back and take a step back and go, what? Like, you promised the man this and then you turn around and do this later. The other part of it too is, once again, going back to this idea of voluntary confessions under Arizona v. Flamez. It's extreme caution. You have, there's a danger here that if we do something like this, give this information to the jury, that they will turn around and say, well, it's unique. He just had his confession. He was lawyer to next to him. He, had every opportunity to talk to his lawyer, blah, 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 blah. But what we haven't said is we don't have Miranda, we don't have any of the other things that would signal to Mr. Davis at the time that he's making statements. That this is not one of those things where you just, frolicking through the tulips and at the end of the day he's going to be okay. We are now in a position where we're saying, look, we want the confession to come in. The problem with the confession, once again, is it sort of puts us in a bad spot. Now, the question that the court might have in your mind is, what's the alternative? Well, the alternative is there's other evidence that the state has that they're going to present to say that, he's the guy that's there, he's the guy that's in the car, and, whatever it is they want to use. But regarding this particular request, this doesn't knock the case out. All it does is it says, hey, this is too prejudicial. The probative value of the 2008 is far exceeded by the prejudicial effect in this case. And if we look at it from that viewpoint, we stay away from it. We don't get involved in it, we don't try to trace the middle, we don't clean up the mess that was made by other people in 2008. What we do instead, we say, look, we're going to move that off to the side, let the jury consider all the other evidence in the case to make their decision at the end of the day as to whether or not the state's net is further beyond the bell. And so as a result, like I said, I think we have to have extreme caution with regards to the statements that were made in 2008. And I think it would be, the most prudent position would be to exclude the 2008-2009 statement.
Can you tell which one of us is real and which one of us is AI? How about now? Does this look real to you? If you thought I was AI, then you'd be right. And if you thought I was AI, then you'd also be right, because...
All right, starting back first. I think really no question on how history will be. I find that as admissible under NRS 51.035 subsection 3. It's clear that Mr. Davis adopted the statements therein as his own through publication, promotion, and subsequent ratification. In his interview to Vlad TV, he promotes this book as his book. He encourages people to buy it to get the real truth, and not from the law enforcement or industry people. He also repeatedly says it's something like the whole truth of the situation. So he's indicated to a reporter also on 10/21/23 that he wrote the book to let people know his truth. He's adopted its contents under NRS 51.035 subsection 3B. And then ultimately, when you look at the entirety of Mr. Shaw's interview, it's supposed that the factual content from the book was from Mr. Davis, and that Mr. Davis ultimately also got the manuscript and made no edits to the description of the murder that's relevant for today. Ultimately, the arguments regarding what Mr. Shaw's contributions to the book are, etc., goes to weight, not admissibility of the book. I really find there is no legal argument to exclude the book. Working backwards, then I'm looking at what's in front of me. The motion is on voluntariness here, right? And so when I'm looking at voluntariness, I started this out saying, first I'm looking for is Miranda required, and then I'm looking to those Pasama factors. And so ultimately, a criminal defendant is deprived of due process if the conviction is based upon an involuntary confession, and voluntariness is determined under the totality of the circumstances, including the age, intelligence, custodial status, and whether coercive police tactics overboard the will. When I look at Pasama, Dewey versus State, and then the Miranda decision itself. When we're looking at Miranda, it's only custodial interrogation. It doesn't require warnings where a defendant voluntarily provides information in a non-custodial setting. Statements offered against a party are admissible where they are the party's own statements or the party's manifested in adoption or belief in their truth. Neither required Miranda, because neither ultimately were in a custody status setting. He was free to leave at all times, and in fact, he did leave for decades after these were stated. So I don't think the Miranda framework is the appropriate one here. Additionally, it's important to note that he was represented by counsel throughout, and that is really what Miranda is. Miranda is designed to protect from police infringement on a person's ability to protect against coercion, and that's what the attorney's entire job is. When I look at the Pasama factors that have been laid out, I don't think they apply here necessarily to establish involuntariness, really. If I apply that test, Mr. Davis passes with flying colors. I mean, this is a situation where he is an adult. He's not inexperienced in the criminal justice system. He has counsel present. He's expressly advised he is not under arrest. He's not inexperienced, he's not uneducated, he's not isolated, he's not subject to prolonged detention, deprivation, or coercive tactics. I mean, he's invited to the situation. He comes to tell his story to avoid the federal government's issue. So I don't find it that it's involuntary either. However, I do have problems with that 2008 interview, but I don't think that they were necessarily addressed in the framework that I'm given here. So I'm not necessarily saying it's admissible. I'm saying it's not voluntary at this time. So the motion is denied as written. So I'm going to carry the order on that.
Thank you. Your Honor, just as a matter of clarification of the court order, is this one of those things where we can address this issue?
You can address it. I don't know what basis it's better, but it's not involuntary.
That's fine, Ryan. And I do understand what this ruling is. I was just trying to figure out the timing and whether or not we can have to address that.
I don't really have a ton of guidance on what I'm saying. I'm just saying that the framework that you presented me that it doesn't fit as an involuntary statement. You are free to readdress it as you see fit under the legal guidance. Gang evidence.
Your Honor, this is the state's motion. Looking at the defense response and talking to Mr. Sams, I think we largely agree that it's admissible for the purposes of motive. So the real question, they took some issue with the purpose of identification, but we're not doing it as a modus operandi. It's more identification as Davis's role within the larger sausage development in terms of why he was the person in leadership in order to issue those commands, why he had the ability to do that. That's what we were looking for in terms of identification.
Okay. Ultimately, gang information is gang affiliation evidence is the bad act, and there's generally some sort of bad acts, petrolly type hearing, although it doesn't really have all the traditional contours of petrolly hearing. But it seems as though Mr. Sanft is not requesting that. He's conceding that it could be necessary for, or that he concedes the evidence of the affiliation with the Southside Compton Crips, personal leadership role within that organization, the rivalry with Bob Hero and the Lakewood Ball and the MGM Grand incidents are probative of motive. And so it seems like we've passed the point where I thought we would need an evidentiary hearing. Would you agree with that?
I agree with that.
On the clear and convincing of the gang evidence.
Yes, Your Honor.
So what it then leaves out essentially is the state is not seeking for identity, and so it's really just for motive. And so we're at essentially is this is a situation where you're seeking for any gang enhancement phase to be bifurcated from the guilt phase.
I think that's an agreement that we would have with the state with regards to that particular issue. The danger is the use of the word shock collar and then the use of the word green light. That's really where we're trying to get at.
Okay, so for you, your concern is those two terms.
Correct. I mean, those are terms that are associated with gang activity, and it's not just gang activity, but it's also associated with this idea of rank within the gang activity. Whether or not Mr. Davis was part of the Southside Crips, I think it's documented. He lives on a street in Burris, in Compton. I mean, it's laid out. I think Detective Vlad would be very clear about the fact that you move into a neighborhood, you're on a street, you become associated with that particular thing. I have a concern about the idea that now they're going to try to shoehorn in this idea that he's a shock collar just by the fact of just using the words and saying he was a shock collar.
What about his own words?
Bob told us that they were going to test the alien craft that night.
I have seen extraterrestrials face to face.
Once again, I think if the evidence comes out that way, I think that's one thing. But at this particular point, I don't believe that they have enough to at least say, hey, we can just throw it out there and make this a thing, like in their openings or anything like that. I think during the course of the trial, if that becomes evidence, that's one thing.
Okay. Shock collar and green light, though?
Yes, Your Honor. So by the court's ruling, the fact of green light is already coming in because it's specifically pulled from Mr. Davis's own words from his book. So, I mean, green light's already coming in. We have a good faith basis that it's coming in based on the court's ruling today. With regards to the shock collar, I mean, that is a term of art within gang hierarchy. The person who actually has the ability to direct orders on other people. And by the way, again, using Mr. Davis's own words from his book, he was the general. He was the president. He was the person that had the authority to make this happen. These are his own words. And so Detective Vlad, when he comes here, him saying that yes, he was the shock collar, he was the person in that hierarchy that could order that retaliation is wholly appropriate given the context of gangs. Now, if the court wants me, I really don't know what I'm trying to work out what's the way to deal with that, other than to just say, we know Detective Vlad testified to that based on his experience. It's the grand Detective Vlad other than to just say, we know Detective Vlad testified to that based on his experience. It's in the grand jury transcripts. That's where that's where this term is derived from. So, he describes himself in this manner.
And maybe what we do in the meantime, Your Honor, is we set this for a very short period.
This term is derived from. So, he describes himself in this manner. Based on his experience, it's in the grand jury transcripts. That's where that's where this term is derived from. We know Detective Vlad, I really don't know what I'm trying to work out what's the way to deal with that, other than to just say, we know Detective Vlad testified to that based on his experience, it's in the grand jury transcripts. That's where order that retaliation is wholly appropriate given the context of gangs. Now, if the court wants me, I really don't know what I'm trying to work out what's the way to deal with that, other than to just say, we know Detective Vlad, I really don't know what I'm trying to work out what's the way to deal with that, other than to just say, we know Detective Vlad testified to that as I don't know what I'm trying to work out what's the way to deal with that, other than to just say, we know Detective Vlad testified to that as based on his experience in the grand jury transcripts. That's where he derived, that's where this term is derived from. So, he describes himself in this manner.
And maybe what we do in the meantime, Your Honor, is we set this for a very short petro here right before Detective Vlad takes the stand. We can make that determination in that particular point with regards to that issue, very narrowly construed. Just we can make that for a very short petro here right before Detective Vlad takes the stand. We can make that determination in that particular point with regards to that issue, very narrowly construed just on the issue of the shot collar.
I think we can, okay, so the motion to admit gang evidence, it seems like it's largely not posting, so it's granted, the state can use it for motive, to establish motive. Regarding the issue, it will be, the gang phase will be bifurcated.
In this manner. This term, based on his experience in the grand jury transcripts. That's where he derived, that's where this term is derived from. So, he describes himself in this manner.
And maybe what we do in the meantime, Your Honor, is we set this for a very short petro here right before Detective Vlad takes the stand. We can make that determination in that particular point with regards to that issue, very narrowly construed just on the issue of the shot collar.
I think we can, okay, so the motion to admit gang evidence, it seems like it's largely not posting, so it's granted, the state can use it for motive, to establish motive. Regarding the issue, it will be, the gang phase will be bifurcated. Regarding the issue of shot collar and green light is within sort of the key sentence that is used, that Mr. Davis uses to describe the murder, the crime that he's charged with.
You, just you, building your app on Base 44.
Yes.
Is used, that Mr. Davis uses to describe the murder, the crime that he's charged with. So I don't think that can be excised. It just doesn't make sense. The shot caller, we can do that with that entry hearing, and we'll hold out until the detective testifies using that particular case. All right, state for your order. Anything further?
Just a little bit. I expect that Detective Vlad's officer's report will be sent over by the end of the week to Mr. Sam. And I know it's a short week, so I'm going to be by Thursday. There were a few other items when I went through them. I didn't see anything, but there's a couple transcripts with a couple audios that came through, and there was 2 audios. I think they're of random tips that came in to either Metro or LIT, and so there'll be one last group of discovery sent over to Mr. Sam by the end of the week.
Okay. So it seems like discovery is on.
Yes. The only thing we still haven't received is the lab. I expect that the lab notes, I think because they're so old, there's literally testing done in 1996, that I think there was some search that had to be done to find it, that we'll get the underlying lab notes as well.
Yeah, there was a couple of things I think was mentioned in the last hearing with regards to discovery, conversations with Compton PD with regards to multiple other police reports that have not been disclosed. Are you talking about the same thing? Are those going to be disclosed as well? Other police reports in the last year?
No, that was 2 hearings ago.
Oh, sorry.
Oh, maybe you're right. Maybe I sent it after that hearing. It was a day or 2 later that I completed all of the review of the Biggie Smalls murder file and sent over everything from that, as well as everything we have from the federal government 302s, the DEA 302s related to the drug transactions that we already discussed here in court today, as well as what we could find on confidential informants and any benefit they received in those prior investigations.
Thank you. And then just one final thing, Your Honor, with regards to transcripts, could we get a transcript of the hearing today?
Sure. Do you want to move House Senate Structural Readiness July 14th, or
We'll be here anyway.
leave it for calendar call?
I mean, we will be in here anyway, July 14th. I think we have a
Oh,
hearing
there's a
on
further motion
questions.
Renee to cut that so we can address anything else. Okay. All right.
Thank you.
Is that your motion, Renee, or stays?
I think it's Mr. Six. It's mine. It's Mr. Six.
All right, we'll see you back.
Thank you.
We'll be in recess. Come on, guys.
The murder of Tupac and the notorious B.I.G. Reggie the Rat Wright Jr. versus Keefe D. And the timeline that was hidden in plain sight.
It's coming up.
Let's get into some of this straight game.
Like cards. It's not what you dealt, but how you play it. I remember they used to laugh at a brother.
Welcome back, guys. Welcome back. It's your boy Delray Richardson, Platinum Artist, Platinum Songwriter, Straight Game TV. I thank you for tuning in. I appreciate your time. Do me a favor. Click on the thumbs up button. Also subscribe to the channel. Like I always say, if you want to be one of the first people notified when I drop some of the straight and says, well, yeah, you know, other people at the club did have their weapon on them. So he's basically saying that other people had weapons on them as far as the security team, but they weren't licensed to carry. This whole thing has been a fuck up from the beginning. Like I said, Tupac was doomed, man. You know, when you think about all of the things, like when you know the actual facts, not the gossip, not the stuff that went on. Like I said, once again, this is, you know, that statement came from Kevin Hackey. Kevin Hackey was, you know, part of Death Row Security. So you have, you know, Michael Moore, Frank Alexander, Kevin Hackey, all talking about this same malfeasance and just negligence and all of the things that went on with the security company from day one. But more importantly than that, right? When people ask who solved the Tupac murder, I believe that they're asking the wrong question, right? I've got a different one for you. I got a different question for you. Who were the federal investigators talking to, and why were so many conversations happening between April 2008 and April 2009? That's the question that you should be asking. Because in between those dates, right? In between those dates, two of the most powerful moves were made involving this Tupac situation and also involving the Biggie investigation. There were two profit deals that were given. One to Keefe D and one to Reggie the Rat Wright Jr. I know of nobody else that was closely involved with this situation, right? And when you think about that for a minute. Two, Keefe D, one being admitting that, he was involved with the Tupac murder, explaining it in his book, explaining it on the Art of Dialogue, Vlad TV. And then Reggie the Rat Wright Jr. And the only thing that I can say in regards to Reggie the Rat Wright Jr. situation is he hasn't written a book in regard. He's written a book about him being some bogus ass label boss, but he hasn't written a book about, why he got a profit deal, right? remember Keefe D was out here touting about, and I got to deal with the, U.S. attorney and so on and so forth. He told that to the Art of Dialogue. But more importantly than that, that's where Keefe D messed up involving his property, right? Reggie the Rat Wright Jr. wrote a book and put something about him being a label boss, right? So he really wanted to write a book, but like I said, his book is a flop. Keefe D's book is about to be a bestseller based on, this trial, because it's going to be something that's going to be heavily, heavily talked about, and best believe the news organizations around the world are going to talk about it, right? So you got to ask, who are federal investigators talking to, and why were so many conversations happening between April 2008 and April 2009, right? Right? Because when you stop arguing over personalities and start looking at the calendar, something interesting begins to appear. And I want to break that down for you, ladies and gentlemen, right? I want you to do me a favor. Stop looking at the headlines. Stop looking at the headlines, because most of these people in these news organizations that are talking, they don't know what they're talking about. They just go on with, the latest snippet from whatever somebody says versus whatever they hadn't said, right? One of the biggest mistakes people make in this case is focusing on individual interviews. They focus on individual interviews. One day it's Keefe D. The next day it's Reggie the Rat Wright Jr. Or Reggie Wright Jr. The next day it's somebody else. But investigators aren't built, or should I say investigations aren't built like YouTube videos are. They're simply not, right? Investigations, or should I say investigations are built with timelines. Simple. It's just that simple. We seen you here, you were there, this, that, the other. Somebody did something. Where were you? Like, and for instance, them having to place Keefe D in Las Vegas, during the time of Tupac's murder, or the shooting, if you will, right? That's going to be something big, but they'll do that probably in one or two or three different ways. You have to see. But the timelines, right? Investigators don't just wake up one morning and randomly decide to interview people, right? Everything happens for a reason. Everything has a sequence. Everything has a timeline. And the timeline you can't run from. I don't care what you do. Like now they got cell phones, and we see the first 48 and how they, show that the cell phone was bouncing off of this cell tower at this particular time. And they ask the person, they basically already know, so where were you at about 10:30 last night? Right? And they waiting for you to lie. Because once again, the timeline says something different, right? And so when you deal with that, that's the most important thing. So let's begin with the first date, right? Let's begin with April 3rd.
Hold on, y'all. Give me a second.
April 3rd, 2008, right? This is the earliest date in the timeline we're discussing today. It's important because it establishes where events began unfolding before the cooperation and interviews that followed. Did you hear what I said? April 3rd, 2008. It's important because it established where the events began unfolding before the cooperation and interviews that followed. You get it? So now, who were they talking to? None other than Reggie the Rat Wright Jr. And it seemed to me that the guilt and all of the things and the lies that had been told up until that point that we had no knowledge of at that particular time. The knowledge about, Reggie the Rat Wright Jr. trying to get Frank Alexander to lie and said Orlando Anderson tried to snatch Tupac's chain. That was a lie. But Reggie the Rat Wright Jr. had to come out and admit he tried to get Frank to admit that. Frank, basically said that. Also, the lie about, trying to get Frank not to show up for the subpoena involving the Suge case or involving the investigation. And in 1 minute he was saying, I just wanted Frank to do his job. And then Frank recorded Reggie the Rat Wright Jr. basically threatening him not to show up for the subpoena. If you duck the subpoena, then everything should be cool. But in public, he was saying, I just wanted Frank to show up, and testify for the subpoena, but he really didn't want that.
That's why Frank had
He really didn't want that. See, these are significant lies in regards, and so why all of these things, one is trying to get Frank Alexander, who was there next to Tupac when the fight initially happened in May. You see what I'm saying? But he would try to curtail that story and say, well, say Orlando Anderson tried to snatch his chain. Ladies and gentlemen, this is how stupid Reggie the Rat Wright Jr. is, because he would have known or would have had to know what? There were cameras. As we see, you don't see anything like that. And in this trial, you're not going to see anything like that, right? So once again, trying to control the narrative is a big, big problem. But once again, it has to do with ego. So when you talk about April 3rd, 2008, right? Like I said, it's important because it establishes where events begin unfolding before the cooperation from Keefe D, right? And the cooperation from Reggie the Rat Wright Jr. Keefe D then gets his proffer deal when? In December of 2008. After Reggie the Rat Wright Jr., like I said, once again, gets hemmed up. You gotta understand this timeline, right? Remember this date, April 3rd, 2008, because everything else builds from this date. So it's fair to say Reggie the Rat Wright Jr. was working with the task force. Was that the same task force that gave him his proffer deal?
And the thing about it, his dad had admitted it soon as it happened. Reggie called him. He said he still was in bed. Remember his dad said that?
That next year, in April of that next year? Man, look, this is some powerful stuff, man. Like I said, if you want to revert back, you can go look at the video that I dropped, the live that I dropped yesterday, right? And then we go to what? December 18th, like I just told you, 2008. Fast forward, right? A few months out. According to court filings, Keefe D gives a recorded statement after being approached during a federal investigation. Ladies and gentlemen, a federal investigation into other activities that he was doing. Once again, but if you go back and look at the grand jury testimony that Reggie the Rat Wright Jr. gave to them, Reggie the Rat Wright Jr. said, Keefe D was known for being a big drug dealer. Once again, being the rat that he is.
Trying to control the narrative.
The government had the cheese, and all they had to do was put it in front of Reggie, and he would rat. It's just that simple, ladies and gentlemen. Listen, but more importantly, the filing states, while denying involvement in Christopher Wallace's murder, he volunteered information about Tupac Shakur's murder. Think about that. I want you to think about that. The timeline just took a major turn. It just took a major turn. Remember the video? I don't know if you remember the video of Reggie the Rat Wright Jr. trying to call Keefe D before Keefe D was arrested for the Tupac murder case. I think it was something about Keefe D's birthday or something like that. And Keefe D told him to eat a dick and hung up the phone. Right? These things all happen, but like I said once again, little do we know, or little did I know, should I say, at that particular time, that what? That Keefe D and Reggie the Rat Wright Jr. got a proffer deal in and around about the same time.
Right.
And I'm thinking, well, damn, how is he so comfortable, with Keefe D like that from that perspective, where he got his number, he can call him up on the phone, and all of these other things, right? These are things that still have to be explained, right? Did Reggie the Rat Wright Jr. know? Or I'm sure Keefe D knew that Reggie the Rat Wright Jr. probably was getting a profit deal around about the same time, right? From what I'm understanding, they were dealing with the same people, if you will, right? But like I said, the timeline from the April 3rd, 2008, from December 18th, 2008, the timeline just took a major turn when Keefe D finally confesses about the Tupac and the totality of everything, but deny being involved with the Biggie murder, based on the fact that Reggie the Rat Wright Jr. allegedly told these people that the murder for Biggie's was payback for Diddy not paying the $1 million for the murder of Tupac Shakur. This is what was the prevailing notion at that time, according to Keefe D, and allegedly according to the underlying investigation, if you will, right? Right? And then we come to March 9th. I believe that was the day Biggie was killed. Not 2009, but 1997. March 9th. Listen to me, this is some powerful shit, because March 9th is when Keefe D does what? He became an informant. Hell of a thing, right? And this trial is about to take place, or is going to be taking place, probably, if it lasts that long, on the death anniversary and the shooting anniversary of Tupac Shakur, depending on how long it takes, right? So March 9th, 2009, according to the same filing that involved Keefe D basically confessing his involvement in Tupac, getting the profit deal and all of that. On March 9, 2009, according to the same filing, Keefe D became an active, confidential informant for the task force. The question is this. Was Reggie the Rat Wright Jr. already a confidential informant for the task force in and around April 3rd, 2008? Because that's when he got hemmed up for the bankruptcy fraud. Remember? Keefe D gets hemmed up for the dope charge. Remember? And everybody start flipping. But that's the question that needs to be answered. Okay, so now we're no longer talking about one interview. We're not talking about one interview no more. We're talking about an ongoing relationship again. I'm not asking you to agree with anyone's versions of events. I'm not asking you to agree with me, nobody else. I'm asking you to notice, once again, and I harp on it, the timeline, right? The timeline, right? So now we go to April 14th. Is the job done? Listen, y'all, I want you to understand, because this is when Reggie the Rat Wright Jr. gets his profit deal. Is the job done? Is the job that Reggie the Rat Wright Jr. and the cooperation and the stories and all of the things, like I said, once again, for him to be pushing that Orlando Anderson narrative, 1 minute, he's pushing the narrative to investigators, and then the other minute, he's trying to tell Frank Alexander to lie and say Orlando tried to snatch Tupac's chain. You see what I mean? Tupac in the hospital fighting for his life. Reggie the Rat Wright Jr. even had a lie for that situation as well, right? So April 14, 2009, Reggie the Rat Wright Jr.'s lucky day, right? Another document, another interaction involving the United States Attorney's Office, the same people that Keefe D was talking to, talking about, should I say, on the Art of Dialogue, the U.S. Attorney. Remember, he told Art of Dialogue, I got to deal with the U.S. Attorney, homie. Da-da-da-da-da-da, right? Now, here's another date added to that timeline. Now, step back for a second. I want you to step back for a second. You have multiple documented interactions involving the federal authorities and individuals connected to the broader Tupac and Biggie investigations. That's why these dates deserve so much attention, right? And the documentation, like I said, that I showed you, if you want to check out the live, you see all of the documentation. But I had to go over this again because, like I said, basically, who were the investigators talking to? Tupac and Biggie, Reggie the Rat Wright Jr., Keefe D. In the timeline that was hidden in plain sight, that most people didn't even pick up on. Remember when I did the Art Dialogue and we put out the documents about Tupac not really being signed to death row? Reggie the Rat Wright Jr. had a hissy fit.
He was signed to Bad Boy.
Who is this guy? Because he was once again trying to control the narrative behind Tupac and all that it was. Tupac was only on death row for 11 months, y'all. Right? And the person who wanted to control the narrative couldn't protect Tupac and Suge Knight when it depended on it, and he was getting paid from what he said, and Suge Knight said, a handsome salary. He failed. He sabotaged the security. This is the person that they're listening to for all of this information from that perspective. Keefe D's situation is different based on the pressure. But like I said, the pressure only came because of allegedly due to the cooperation of various people. But Reggie the Rat Wright Jr. wants to take that credit when he gets no credit. He failed. His job was to secure Tupac Shakur and Suge Knight on that night, being an employee from death row. Not after Tupac fired him on August 27th, 1996, basically for not giving Tupac or allowing Tupac to take his music out of the studio. He still worked for death row. And when Suge Knight asked for more security, he was supposed to send it. When Frank Alexander asked for more security, he was supposed to send it. But Reggie the Rat Wright Jr. was so salty and beside himself, he said, fuck Tupac. And I showed you the video where he said, fuck Tupac. He didn't care. It didn't matter no more. He couldn't get that little extra $300 or $400 for the little off-duty, off death row hours security that he was providing for Tupac, because Tupac fired him, along with David Kenner at that particular time, right? So when you understand that, you have multiple documented interactions involving federal authorities and individuals connected to the broader Tupac and Biggie investigation. Like I said, these dates, nobody's talked about. You heard no news organization grapple with these dates. They've dealt with the Keefe D dates in court because they have to run the timeline down based on, trying to prove this case. But you never heard about the Reggie the Rat Wright Jr. situation being in the same approximate time, right? And here's the question that nobody's asking. And this is where I think the conversation changes. Everybody wants to know who solved the murder. Who told first? Who snitched first? Who told first, right? And those are fair questions. But I think there's a better question, ladies and gentlemen. What were the federal investigators trying to piece together between April 2008 and April 2009? Because investigators don't conduct interviews in a vacuum, right? They don't do it that way, right? They compare statements. They build timelines. They test stories against evidence. That's how investigations work. And so, was the information that Reggie the Rat Wright Jr. provided so powerful that he was guaranteed, if he told everything that he knew, that he would be able to get a deal too? Right? Because Keefe D got a deal. Remember, Keefe D got his deal December 18, 2008. Reggie the Rat Wright Jr. didn't get his until what? April 14th, 2009. You get it?
All right.
So it's not who solved them. It was who began talking first. Or should I say, who told first? And I want you to understand that the calendar or a calendar does not have an opinion. I always tell people, witnesses can disagree. Memories can fade. People contradict themselves, but the calendar doesn't pick sides. The calendar simply records what happened and when. That's why timelines are so powerful. They force us to slow down and look at the sequence instead of reacting to isolated headlines. And that's, that's the, the gist of a news cycle. The time, what happened today in court, or what happened today, or this person comes out, this is da 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 da. Instead of being correct, they want to be first. It's about being first most times, right? And like I said, I'm not here to tell you that these dates answer every question. I'm not here to tell you that because they don't. But I do believe they point us towards better questions, better grounded in documents, questions grounded in chronology, right? Questions that help us understand how this investigation evolved over time. Sometimes the most revealing part of a case isn't what was said. It's when it was said. When it was said, the time and all of those things to point out, right? So like I said, so let me ask y'all this, man. The people in the chat, the people that may watch this video. Instead of asking who solved the Tupac case, ask yourself this. Who were federal investigators talking to, and why were so many conversations happening between April 2008 and April 2009? Right? Is that 1 year window simply a coincidence, or does it deserve a closer look? Drop your thoughts below. Let's discuss the timeline. Let's discuss the documents. Let's keep separating evidence from speculation. Right? Like I said, ladies and gentlemen, I appreciate your time. I appreciate you tuning in. Yo, your boy Del Rey, straight gang.
There you go. But I'll be back later on with some more information, man. We gone.